General conditions of sale grant businesses the power to outline the legal framework of their commercial relationships. These conditions are unique to each exporter, defining the seller's rights and helping them protect their interests. It's essential for these conditions to be drafted clearly and without ambiguity. They are usually written in either the buyer's language or English. Exporters must focus on crucial elements like price, payment terms, delivery timelines, and dispute resolution procedures. Before a contract is finalized, buyers must review these general conditions, or they may be deemed legally ineffective. In some countries, general purchasing conditions are enforced, often conflicting with those of the seller, which necessitates negotiation. A buyer's silence is typically considered as acceptance. Acceptance of an offer signifies the client's agreement, thus concluding the sales contract. A contract becomes real once the offer is met with acceptance. Otherwise, the offer can be withdrawn. Acceptance should be in written form to provide the seller with proof and guarantee in case of disputes. Usually, this acceptance materializes as a purchase order or contract. Oral acceptance isn't advisable due to the lack of evidence. Written confirmation is always recommended. Note that telex or fax acceptance is insufficient proof in disputes. Companies often use template contracts to formalize agreements, which are convenient but non-negotiable. Bespoke contracts tailored for each client are the most secure approach. Contract clauses include identifying the buyer and seller, defining the contract's purpose, and specifying technical details, quantity, volume, weight, and packaging. Price and payment methods should specify the price in euros or foreign currency, considering exchange risks. Include Incoterms clarifying the sharing of transport costs, duties, insurance, and transfer of ownership timing. Detail the merchandise's cost, unit, and total price. Choose a payment method ensuring maximum security for the seller. Down payments guarantee the order. For documentary credits, the seller notes the opening request. A retention of title clause can be added, if legislation permits. Transport arrangements determine transport mode aligned with merchandise nature, destination, and security. Depending on Incoterms, clarify the contractual obligations. Delivery terms establish the loading and delivery time and place. Set timelines from contract commencement. Adherence to delivery deadlines is crucial, so prearrange delay penalties. Force majeure circumstances should be specified. Avoid accepting the buyer's force majeure unless essential. Warranties outline parties' commitments regarding warranties, e.g., refund guarantees from the seller. Jurisdiction in case of dispute decides applicable law for resolution. French law isn't always ideal due to its buyer protection stance. If opting for the buyer's law, ensure full understanding. Language determines contract language, accessible to both parties, and be wary of translation issues.